So this meeting is being recorded. So here we go. We are proposing a general plan text amendment that will amend the general plan and require applicants who submit a privately initiated general plan amendment to submit that GPA application together with a permit application. And we will then consider the two concurrently at the same planning commission hearing and city council hearing. So currently, we do see folks submit a general plan amendment without a project. And now we would like to require that general plan amendments are submitted together with the project. So the sort of the background on this, or the reason why we feel this is an important step to take for the city is that submitting together with a project would be more defensible in the CEQA analysis. So there are some new state laws that require there are new state laws that have streamlined permitting for housing, and the general plan amendment process and CEQA need to analyze and disclose the environmental impacts of the general plan amendment and streamline development facilitated by the general plan amendment, which requires a specific project. So we are looking for this change because it would minimize legal challenges to segmentation or piecemealing. If the development application is included as part of the general plan amendment, it would ensure that the CEQA analysis reviews the whole project and would eliminate any issues of piecemealing or segmentation, which is not allowed under CEQA. Recently, we have found that the city, as it is built out, the proposed general plan amendments are sometimes in more sensitive areas. For example, converting a residential use in a red VMT area for per capita development. These kinds of general plan amendments with or without a project would trigger a higher level of CEQA analysis. For example, an MND or an EIR, and both of which would require implementation of an MMRP. And having a project on file would not only reduce the processing time for the project, it would also provide a permit, an anchor for the MMRP to ensure compliance and ensure expectations for the development are clear to the applicant, the community, and to staff. So we also want to see that the city council and the community, the decision-making body, is clear on what the project is. And if the project and the general plan amendment are going to result in development that will meet and further the vision, the major strategies, and the goals of the general plan. So here are some of the specifics of what we're trying to do. So it's, again, I will repeat this, that we want to see the general plan amendment submitted together with a project, so we can review it concurrently. And there we are going to include a pipeline provision, so we don't want to impact projects that have already been submitted, or that that don't have enough time to take this into consideration. We want folks to have enough warning. So we're looking to apply this new policy to the 2024 general plan cycle. So this is slated for the December Planning Commission and City Council hearing meetings. And I mean, this is my last slide, but we are open to a discussion at this point. We have some folks in the chat. Yes, I can provide you with the slides after the meeting. And Ray has his hand raised.
Thanks, Karen. I'm sure there's some other questions from other people in the development community, but whenever there's been many times in the city where we do these general plan amendments, and then not soon after they put in place, there's almost a reason that you want to have some exception to it. So the general plan is written fairly generically. So I'd hate for this to be put into an airtight situation where you can't do anything but this. So I'm looking for some flexibility in doing this. And yes, our company's been involved with general plan amendment, plan development, or zoning with a development permit all at once and gone through the whole way, which is fine. But I think there's some instances where that's a lot of money to be expended on development permit plans when, as part of the development community, you want some certainty. So if you're going to spend that kind of money, and you could take it a step at a time by saying, is the general plan amendment even going to be approved? And if not, then I don't have to, then I'm incrementally taking some risk as opposed to having to put everything together. So I want to know if there's some, sort of flexibility in how we're going to apply this GP text amendment. And I don't know if there are other people that are having similar question, but that's one of the things that I see as potential issue.
Are you saying that you would want like a sneak preview of the likelihood of your general plan amendment getting approved?
Yeah,
or you want flexibility to propose a different project?
No, I think you should. I think there should be the ability to do a general plan amendment without having to necessarily do a development permit. And maybe there's some other process. Maybe there's the preliminary review process, what have you. But to go through the extent of providing development plans with grading and drainage plans, stormwater quality plans, landscape plan, everything as part of a general plan amendment is a big commitment. So.
Yeah, Ray, thanks. That's good feedback and something we need to consider. So one thing that isn't on that proposed policy, but we thought about actually this morning that may get at least partially at your concern is the idea, because we hear you that like you just want to get a thumbs up or thumbs down without doing drainage plans and grading plans. So one thought that we did have, which may partially address your concern, is that one approach is that if you just had like a sort of a PD zoning level, right? So you don't need grading and drainage and architecture, but you just had, here's the parameters of the uses, the heights and the intensity, that might be an approach that might be more of a middle ground, so that at least that gets us more of a project level to do the CEQA analysis, and also gives the council sort of more of an idea of what would likely be built when they approve the general plan amendment. So that's another approach, but we'll take into consideration the other thing that you mentioned. Is there sort of another way to get at sort of a thumbs up or thumbs down before you start dropping a lot of money on architectural plans?
And following up on that, I don't want to take over the meeting, but is there ability, or is the city looking at doing general plan amendments more than once a year, so that maybe there's more of a chance for you to get going on some of these things, and knowing that it's a little quicker when you're going to make this kind of investment? Can you do it before the end of the year or before the fall hearings? Is there any way to add more general plan amendments or allow general plan amendments all year long? So, I mean, that's another thing that I think the development community is looking at if they're going to have to make a commitment of to, you know, go all the way with development permit in hand.
Okay. Yeah, thanks.
Hey, it's Sean Morley. I couldn't see the raise hand button, but does this only apply to housing projects or across the board? It wasn't clear.
Across the board.
Okay, so the challenge, I think, and some of it touches on what Ray said, but just practically speaking, if you've got a project that is going to require an EIR, even for the general plan amendment, one would have to file it. I can't remember your schedule in October or November. Just given the city's development review process, if I was to do that for 2024 next November, it would be impossible for me to complete the CEQA process and the design of the project leading up to it, setting aside the cost. But even with that, as Ray mentioned, you know, if you're only looking at one general plan cycle for, you know, publicly initiated or privately initiated general plan amendments, it makes it really hard. Nobody practically, though, is going to go through that process or spend the money if the city has its early denial policy in place. You're basically asking somebody to make $1 million, literally $1 million, 2-year commitment before they even know whether they're going to have, you know, a practical understanding whether the project is going to get approved. That is a big investment. It's going to have a reverse effect going into a recession of having, you know, a pretty big stifling effect on economic development projects that you may want. And you're not going to be able to, even as a staff, unload those with sort of an off ramp or a fail safe like Ray was suggesting. But as a practical matter, and I understand some of the issues you're contending with because of changes in state housing laws and the compliance, but you know, I think you may be able to more surgically identify those instances where that needs to happen potentially. I mean, you're essentially going to functionally stop any privately initiated general plan amendments if you include a link like this, which is going to miss out on some economic development opportunities and fairly significant ones. So I would hope that the city would consult with the economic development team and, you know, at least account for those kinds of issues, because it's a fairly significant one. And just the last, you know, matter, I mean, there are a number of us on the phone that have been doing this well over 30 years in one form or another, including having worked for the city, myself included. And, you know, there's always been a bright line. I've been lectured by multiple planning directors about the need to have long-range planning separated from specific, you know, shorter-term development review. There are property owners that make decisions about their property over a long period of time and want the certainty and the ability to just look at a long-range general plan adjustment as outside of a particular project. That's good and healthy for everybody and from a neighborhood standpoint, you know, and I think you would be functionally eliminating the ability for anybody to do that. So I see the problem, but I'm not sure this is necessarily, you know, at such a large level the solution, but it will have significant, I can think of 3 projects that I've been involved in privately and when I was at the city that this would have precluded, not the least of which was Cisco coming to San Jose back in the 90s. If this sort of thing had existed, they wouldn't have come.
Yeah, and I think thanks, Sean. So I think a couple sort of things, again, we were thinking about on this, or one idea based on kind of your feedback is, you know, I think you alluded to it, but there could be an opportunity for an applicant to request early consideration. So they get at least a thumbs up. Yeah, we want to think, you know, we want to consider this versus no, we don't. So that way they get a sense of like, okay, should I plow forward or not? We have to think about how that would work timing, but that could be something that could be part of the process if an applicant wants.
Yeah, I hear you.
Yeah. Yeah.
I would just say that, you know, with respect to the parsing of a PD permit or a PD zoning or something like that, I know that's not quite the issue you're talking about. It's a practical matter. You can't, for a fairly intense project, it's impossible to design a PD zoning at a macro level to meet all the city's requirements to process an EIR, even if you can get the application on file without really doing everything you need to do for a PD permit. So even though you may not require it, we still have to produce it in order to get the EIR process for the PD zoning. And so I'm not sure it's as simple as parsing those things. And your administrative procedures today require, a full application to get the general plan amendment on file. You would have to do all of that. You would need to make some adjustments to your either early decision, or I don't think it's called an early review or preview. I think it's called early denial, which is a big impediment. And one of the reasons I think why you created that policy was to, encourage people not to propose, at least from staff's perspective, bad amendments. I think this policy in some respects, will have that same impact, even if you're trying to solve a problem. So.
I'm curious if any of you, because I know that some cities have already require projects with general plan amendments. I'm curious if any of you have worked in cities that have that requirement on the books. Because we found that other cities do this, and so just have you guys experienced that before in other places? Okay, so I take that as a no. All right. Back to you, Karen, for fielding comments and questions.
Okay, Stephen Lynch.
Hey, I'm going to end. So per Michael's kind of thoughts, yeah, I think most cities out there require general plan and rezone to go concurrent with the project. And I hear what Sean is saying, particularly for some larger projects that have been under family ownership for a long time. I don't think they're ever going to get to a point where they're sort of having $1 million all-in moment on, make or break this family property. I think that is an issue. And I think other cities that do have this process, they don't necessarily have large and long-term property owners as much as at least we see in San Jose. But I will kind of take the flip side from the development side. And that's kind of, I don't know how you can process a general plan amendment without knowing the micro details of the project behind it. And I think that when we begin to see a general plan amendment coming through, I don't think we from the development side could predict all of the little issues, all of the exceptions, everything we need in the general plan amendment, the rezone. We can't predict that up front until we're down into 100 pages of design for the project. And that's why, as Ray said earlier, you have these general plan amendments, and then you go through the process and realize you have to make even more changes to that. So I honestly, I would like to see a process as concurrent review. It's difficult in San Jose doing this only once a year. I think everything should be rolled into one large application process, but I don't see a reason why you can't have a subsequent process to accommodate exactly Sean's concerns about the larger projects that only want a general plan amendment. But from a development side, if we can go through everything in one fell swoop, I think it's much clearer for staff to process. It's much clearer for us to process. And frankly, it's a lot more digestible from the public to understand exactly what this general plan amendment means to them. And that's the confusion we see a lot. So
and Steve, my only was nothing precludes that from happening today. If you want to file a concurrent application,
right,
PD zoning, PD permit, vesting tentative map development agreement, knock yourself out. Nothing precludes you from doing that today. But there are many instances where that's not the case. In fact, we've processed 2 in this sequence just in the last 5 years. I think one is probably 2. I think at least 1 in San Jose. There's nothing that precludes it, but if you lock it in, it's going to be a challenge. Sorry, I didn't mean to rain on your.
No, that's right. Nothing precludes it except when you're told that you can't do it and you have to come to the general plan first. So,
well, actually, I mean, I've done it both. I've done it both ways, and San Jose doesn't preclude you. They can't preclude you from filing the applications and processing them simultaneously.
Well, just sort of a follow-up question. I think I heard the idea of more than one general plan cycle a year. I know that the development community would like that. We hear that. But would that sort of address some of the concern with the requirement of projects? Or is it like these concerns sort of are larger than that? Or I just want to get some thoughts on that from y'all. I mean, is that idea really tied to your concerns about the project plus GPA, or is that sort of something else that you'd like to see? Or do you think that would sort of help mitigate some of your concerns in requiring a project with the GPA?
Ray, go ahead.
Oh, thanks. I put that out, Michael. I don't know if it gets to the root of the problem of some of the things that Sean talked about as well, but it would give more opportunity during the year, and maybe you wouldn't have to wait a whole year. You do a lot of stuff your first year and then be able to go in the spring of the following year, as opposed to wait to the end of the year. So I'd like to hear other people weigh in on that, but just having more of an opportunity, if it was even twice a year, to be able to save some time, because time's always our client's enemy on this stuff. So I don't know. I don't know if that's the solution. It may be, but I just threw that out as food for thought, frankly.
Yeah, Ray, I think if there was a true 4-time-a-year general plan amendment process where you knew you could slot into a quarter, I mean, when you're processing this many applications, you can manage the timeline. But when it's once a year, it creates massive risks if you miss it by a day, including if you can't get, just argument's sake, Department of Transportation to approve your scope of work for your LTA, and it causes a 3-month delay. It's happened many times. And all of your ability to submit the environmental document is tied to that. And you've got to hit a deadline, which is 1 day out of the year, in order to be able to submit, in order to be able to be heard a year later, right, at the earliest. And just let's not kid ourselves when we're talking about projects that are, have economic, well, even residential projects, but, especially commercial projects. You're asking somebody to make decisions 2 years potentially earlier than they might otherwise under the current schedule, to project, an economic condition that they're playing to. It's hard enough as it is with the cycle. And so I just can't overemphasize the timeline issues. There is an elongation of a process, and it doesn't necessarily speed it up with concurrent processing if you're only doing it once a year. And twice a year, I don't think is going to be enough.
Actually, Dina has her hand up virtually.
Yeah, thanks, Michael. I do think that multiple hearing cycles would help, but I think the larger issue is, I mean, over the years, we've filed multiple general plan amendments on behalf of our clients, and then just to be told to go away via the early denial process. I mean, one that comes to mind is the Smart and Final that was built at Race and San Carlos. We had proposed a general plan amendment for mixed use there. We thought it made sense, and we were flat out told to go away, never going to happen, after we filed our application. So if we had to prepare full PD permit plans or full development permit plans before that, that's just a huge waste of time and money for something that was never going to be considered, even though it made sense and it was something that the neighborhood actually wanted.
Right. And so that's, I think, kind of building off, I forget who now mentioned it. I think it was Sean, but if there was a process where you could get sort of a tentative, like not a thumbs up, but the council could say, listen, no way, you're done. Or this is an intriguing idea. We'd like to consider this before you have to do all the work to do a project or a zoning or whatever it may be, and package it together. So like, I guess what I'm hearing is thinking about some kind of process where there is an opportunity to get initial feedback, not just from staff. We always are happy to give you initial feedback, right? But from the elected decision makers, so that you have a sense of, is it worth the developer's time to actually do the work to package up a proposal? So yeah, that's a valid concern. We hear that. So we'll think about that.
I was just going to interject, and I'm assuming most of you also know this already, but we we were really going to try and push people to not requiring it, but pushing and highly recommending people to do prelims before they submit GPAs, because we can review some of those things. Like you at least can find out like, you know, from staff, like, no, we don't think it'll ever go past. And prelims costs $1,000, you know, it's a drop in the bucket compared to the rest of the cost of a GPA. And so we would highly recommend doing a prelim on, you know, what kind of, like, whether it could be on just the GPA, it could be on also the project with it. But it's a really cheap option to at least get some kind of feedback on it ahead of time. It's maybe not from council, but like that might be like, if it's a maybe, it might go to some council to see if like they want to give you a go forward on it. But if it's a definite no, then you know really early on, like, nope, staff isn't going to support it, costs you $1,000, and you don't have to spend the cost on, you know, applying with the GPA or the PD zoning or site development permit, any of those kinds of things. So just another option out there for you guys.
Any other questions or comments? This should be a juicy topic, y'all. Come on. Okay.
Michael, I just got to reiterate, because I thought I'd have more folks chiming in on this. Maybe people are just still absorbing, but we're going into a recession. San Jose's already got a lot of procedural hurdles and challenges that other jurisdictions immediately adjacent don't have. You do not need to be putting another tool in place that is going to make it even harder to deliver good economic development. We work on residential projects, we work on big commercial and industrial projects, big mixed use ones. Just beware of unintended consequences, and you know, make sure that you're planning accordingly for them with this. I don't see how you protect your economic development objectives by putting something like this in place. And it's not just a little problem, it's a big problem.
Okay.
Michael, I would certainly agree with what Sean's saying, and I would use as the example, you know, we had all the best intentions and making sure, you know, well, in this case it's CEQA, so you're not doing things that we're gonna you know, put you at risk with CEQA. But when we did all of the village plans, and our intent was to be able to get those up and running and get economic development going, then bring housing in, and that just hasn't been successful. So I'd hate to write something into the general plan which doesn't have some wiggle room or some ability to do something differently if the need is there, because all the boxes that need to be checked in that village plan just didn't work out very well at the end of the day. So I don't want this to kind of go down the same path and put into writing and in the general plan a procedure which, as Sean says, makes it more difficult for development to take place and in particularly economic development.
I think you can accomplish the same thing too outside the general plan, just if you wanted to, by adopting a city council policy with respect to, you know, or modifying one of the ones that exists. It's been a long time since I've looked at them. That also gives you the option, if you've just totally blown it, or you want to do something, you don't have to yourself wait a year to modify the general plan to fix it. You know, I think you can probably achieve it that way from a procedural standpoint, as opposed to having an absolute requirement in the general plan. I don't want to. Yeah,
and we'll consider that, and you know, think about what the best vehicle would be. But I think the main takeaway is that, okay, so having this as a general rule could be okay, as long as there's a process to allow those kind of extraordinary situations where you really, the council would, it makes sense to really do it out of the project. So
I wouldn't fall into I'm not in the it may be okay category. I think it's not a good idea, but that's just me. I would ask you, Michael, to answer the following question though. If staff is going to recommend general plan amendments, because these are privately initiated, would you apply the same standard to yourself? And you wouldn't, and you couldn't.
No, because the thing is, we're doing things usually at a more of a policy level. I mean, we don't do a lot of land use amendments. When they are done, it's usually related to a 4-year review of the general plan process.
And but
Yeah.
then that's
Or a
why we
comp-
have a general plan, right? Long range planning. There is a demarcation, and I encourage you to find a way to maintain it. Because again, not unless I misunderstand your regulations, nothing precludes somebody from bundling all those together. In fact, we've done it a couple of times in the recent past in San Jose.
Yeah, and again, the reason for this is we're finding that many people are not, and it's creating challenges and issues. And yeah, and so there's a lot of a lot of uncertainty about what's going to come politically as well. But there's the CEQA stuff. So that's the driver of why we're here, which Karen went over at the beginning.
Wait a minute, uncertainty about politically, you mean council changes? You guys don't need to worry about those things. Come on.
No, it's more that so we have proposals coming in that it's not really clear what it is, right? Or at least, and I think having some clarity on, well, if the council changes this, not just for the council, but for the community and other stakeholders, what does that what is intended to happen later, right? And once you start getting into an actual talking, oh, this is what we're going to do, then it starts to getting into issues of, well, wait a minute, we should be analyzing that as well, because they're talking about what they intend to do. So it gets into the piecemeal.
Yeah, and I mean, just give you a really good example. A lot of people have, they sought general plan amendments to go from IP to CIC because it creates more economic debate. Even in the industrial category, it gives you more options, even just to lease your property, right? To come in with an actual application that's conforming and everything. I would, but even that's a perfect example. I mean, we've done that for a number of corporate users in North San Jose and other locations, and with the encouragement of city staff. But I'm not sure anybody would go through that process without a tenant or otherwise. Again, I can raise a number of examples where it creates problems. It's just not totally clear to me the specific instances that you're trying to solve for, and a single solution may not be really the best approach here. But anyway, I think I've talked myself out.
We have 2 hands raised. I'm going to go to Kim.
Yeah, hi, thank you. I think Ray and Sean summed it up pretty well from a development standpoint, right? For our company, right, we're seeing how we can make it easier through cities right now, not more complicated, right? Those projects are getting prioritized, that we think that there's a little bit more flexibility and nimbleness to move quicker. And, I completely agree with these guys, especially as we get into kind of whatever the next financial tranche is, right? We're going to start pulling stuff back, and we want to continue developing, right? We spent a fortune on our property, and we want to continue to do that. I was in a meeting this week about already looking at kind of what's the next thing. But the priorities and the projects that are getting kind of prioritized are ones that we have more nimbleness and more opportunity to move quicker. So again, anything we can do to continue to expedite the process rather than potentially slow it down or burden too much up front, as the guys communicated, the more opportunity I think we're going to have collectively. But I appreciate the efforts. But again, it's all about speed.
Are you guys looking at projects that would need general plan amendments?
Yes.
What's interesting. Okay.
Possibly, yes.
Okay.
Again, and I'm getting a little more up to speed, not having worked on some of the historical work at our property. So I'm digging into all that, but I would think so, possibly.
And you mind sharing which property are you referring to?
I work for Westfield, the shopping center.
Okay. So it could be one of the Westfield malls. Okay.
Yeah.
And
most likely the behemoth, then the little sister.
Okay.
I mean, it could be both, but right, we know the investment we've recently made up at Valley Fair.
Okay.
Okay, Michael.
Thank you. I would just reiterate what Kim has just reiterated for Ray and Sean. I'm curious, where are you in this process, and more specifically, what other constituency groups, i.e. your internal economic development staff and/or your city politicians, city council members, mayor, where have those constituency groups been sort of involved in this process?
So, well, yes, I mean, when we have our CSA, which includes economic development, and so we've been working on things like this with economic development, and of course, Chris was a deputy in economic development. So we definitely have. We've had conversations with the mayor about this. And we've been talking to council offices about it as part of our regular check-in meetings. So, some of them may not, some of them may not fully understand it all. That's fair, but we have been talking to them about it.
And for how long has this been sort of in the mix, Michael?
I would say the initial conversations with the mayor was probably about 5-6 months ago. And then the council office, we bring it up as part of our one-on-ones. I don't know exactly, that's been happening over the last couple of months, and we're going to continue to do that. But in terms of like other stakeholder groups, like beyond the development community, no, we haven't. And frankly, we weren't planning to. I think you guys have an interest in this, and we can't really think of one other group that would be easy to reach out to get feedback on.
Thank you.
Are there any more questions or comments from the group? Kim, go ahead.
Yeah, could I just ask one more question, just from a clarity, kind of the intent of why you guys think this is necessary? Is it something that you're getting pressure on? Is it something you think from an efficiency within your own department?
Well, I think so. I don't know if Cassandra, you want to step in. A lot of this is being driven, it's come up very recently because of state law changes related to streamlining and the challenges that we're having with environmental review when we're just doing color changes to the map. And mind you, this issue isn't just impacting you all, it's actually impacting us ourselves in long range planning. We're having real challenges doing citywide policy changes because of state law changes related to streamlining. So one of the things that we would used to do is we'd come up with a policy change for the city, like for example, Yigby, maybe you guys have heard about that, right? Allowing housing with churches. And in the past, we would do a program level analysis. And we would say, well, we're not going to analyze the more project specific stuff because there will be CEQA analysis down the road when a project comes in. But because of streamlining now, there is no CEQA down the road. So that means we're having to do a lot more CEQA up front, and we're finding a lot of challenges to do that with our own work. Actually, it's really a nut we're trying to crack here. And so similarly, we're finding challenges with when an applicant submits a general plan amendment also without a project. So, I think in many ways, I think it's a better approach for CEQA, but in a lot of ways, at least for the housing GPAs, it's being driven by state law changes and the challenges, the unintended consequences that those have created for us. That really is frankly the driver of this. It's not like, well, we love planners like this, or that it's better to tell the community what they're going to get with a GPA. I mean, that's another fact, but that's not the driver. The driver is CEQA, streamlining law, and what the challenges it's created to our environmental review process. And I would just say we wouldn't be here today if it weren't for that issue. That's the driver.
Thanks.
I was just gonna interject and go off of maybe what Kim was saying, but is there any suggestions you or other developers may have on like what else could potentially make the process easier for you, since we all have you here?
Again, I'll let the guys have done a lot more work here than I have in this, but I've done a lot of other jurisdictions, but
conversation.
yeah, pass the baton there.
I mean,
I think that's a can of worms you want to open up at another session.
Okay. Good to know.
Fair enough, Ray. Okay.
Thank you very much.
Do you want to take us out? Or I guess.
Sure.
you want to take us out, Karen?
Yeah, so if folks have other questions or comments that come to mind in the next couple of weeks, feel free to email the general plan team or give me a call and we'll record your comments. I have received one phone call and some comments via email from folks who knew they wouldn't be able to make this meeting time slot. And we're collecting all of that to fold into the analysis.
Karen, was the language you showed on one of the first slides the actual language that is going to be included?
Oh, no, we have a draft so far. We haven't finalized the language of this text
would be
amendment
great.
yet.
You know, we don't have the luxury of doing that. You all do, and a lot of times we don't know what we're shooting at, right? Is this the actual text or is it something close to
This
this?
is the draft.
Okay, got it.
Yeah, this is a draft text that we came up with, but as we hear conversation, this is for the purposes of this conversation, right? So
Understood.
it's very well, we'll start tweaking it, right?
Yeah, if there was a much longer version of it that we should be looking at, I think.
No, not at this point.
Okay. All right.
Yeah.
Okay, so we can conclude the meeting there. I will send an email including the slides. And if anyone has any questions, you know where to find us. We're all ears. So thank you very much.
Thanks, everybody.
Have a lovely afternoon.